I gave my son and his wife exactly what they demanded in court, and their lawyer only needed one sentence to make them realize what they had truly done. I remember the way the courtroom smelled that morning, like old wood and polished floors, sunlight filtering through tall narrow windows and landing in pale stripes across the benches. I sat at the plaintiff's table in a navy blue suit I had bought 10 years ago for my husband William's retirement dinner, my hands folded calmly in front of me, my wedding band still resting against my knuckle even though he had been gone for 3 years. Across the aisle, my son Daniel avoided my eyes, studying a stack of papers as if they contained the secret to his future, while his wife Ashley leaned toward their attorney, whispering with a confidence that almost looked like relief. They believed the hearing would end with my signature transferring control of our 40-acre ranch outside Austin into their hands because they had convinced themselves I was too old to manage it, too forgetful to balance the accounts, too fragile to understand contracts written in 12-point font. I did not correct them when they described me that way in their filing. I did not object when their petition stated that granting them full authority would be in my best interest. I simply listened. The judge adjusted his glasses and asked if I understood the documents placed before me, and I answered that I did. I understood more than they imagined. 72 years of living teaches a woman how to recognize the sound of impatience in her own child's voice, how to detect when concern is only a softer word for control. 3 days earlier, I had stood alone in my kitchen, staring out at the pasture fence William and I had painted white every spring, when the certified letter arrived announcing that my son was seeking legal guardianship over my estate. I read it twice, then set it beside the coffee maker and turned off the burner beneath the kettle, because there was no reason to let water boil over a piece of paper. I drove my silver Buick the 20 miles into town and met with Mr. Benson, the attorney who had drafted William's trust years ago, and we reviewed every clause together while the clock ticked steadily above his bookshelf. I did not raise my voice. I did not accuse anyone. I only asked him to confirm that the language my husband insisted on remained intact. It did. Back in the courtroom, the bailiff handed me a pen. Daniel's jaw tightened, Ashley straightened her shoulders, and their lawyer cleared his throat with the assurance of a man who believed the outcome had already been negotiated. I signed where indicated, the ink flowing smoothly across the page, and slid the document back across the table. There was a brief shuffle of papers, the quiet rustle of expectation, and then their attorney began to read aloud the final provision attached to the trust, his tone steady at first and then slightly strained as the words settled into the room. Under Clause 14b, any beneficiary who challenges or attempts to seize control from the grantor forfeits all inheritance rights in full. The sentence hung in the air longer than any argument could have. I watched Ashley's color fade, watched Daniel finally lift his eyes to meet mine, confusion replacing certainty. I did not gloat. I did not speak. I simply gathered my purse, stood carefully on my sensible heels, and felt the calm that comes when a promise is kept exactly as written. The hallway outside the courtroom felt colder than it had an hour earlier, even though the Texas sun was already climbing high above the courthouse steps. I walked slowly, not because I was weak, but because I wanted each step to feel deliberate. My heels echoed against the tile floor, steady and measured, the way William used to walk when he was certain about a business decision. Behind me I could hear hushed voices, the low murmur of confusion that follows when expectations collapse without warning. I did not turn around. I pushed open the heavy glass door and stepped into the bright morning light, breathing in the warm air as if I had just finished a long swim. The ranch was 20 miles outside Austin, a stretch of open pasture and oak trees that William and I had bought when Daniel was 8 years old. Back then it was nothing more than $50,000 and a handshake with a man who believed in hard work. Over 4 decades we turned it into something steady and reliable, something that paid property taxes on time and never missed a payroll for the 3 men who helped with fencing and livestock. When William fell ill, he spent many afternoons at the kitchen table with a yellow legal pad, reviewing documents and asking careful questions. He believed in preparation. He believed in consequences. He also believed that love did not mean surrendering wisdom. I remember the night he told me about the protective clause in the trust. The kitchen light flickered slightly over the sink, and the cicadas were loud outside the window. He said that if anyone ever tried to take control by force of paperwork rather than conversation, they would reveal more about themselves than any argument could. I had laughed softly at the time, telling him our son would never do such a thing. William only squeezed my hand and said that people change when they think opportunity is within reach. After he passed, Daniel visited less often. Ashley handled most of the phone calls. She spoke in careful tones about simplifying my life, about moving me into something smaller and easier to maintain, about how the ranch was too much land for one woman in her 70s. 40 acres can look overwhelming on paper, but to me it was only fence lines I could trace with my eyes closed. It was the red barn that Daniel helped paint in high school, the pond we stocked with base one summer, the stretch of pasture where William taught our son how to drive a pickup truck in slow circles until he stopped stalling the engine. When the petition arrived claiming I was incapable of managing my own affairs, I stood in the doorway of that barn and listened to the quiet. The cattle were calm. The wind moved evenly across the grass. Nothing about the land suggested chaos. The chaos was in a courtroom file with my name typed in bold letters. As I reached my Buick in the courthouse parking lot, I unlocked the door and sat behind the wheel without starting the engine. I rested my hands on the steering wheel and allowed myself one honest thought. Daniel did not challenge my memory because he believed I was confused. He challenged it because he believed I would yield. That difference mattered. I adjusted the rearview mirror, checked my reflection, and saw a woman who had spent 50 years building something solid. I started the engine and drove back toward the ranch, the road stretching straight ahead under the wide Texas sky, knowing that what happened inside that courtroom was not revenge. It was a boundary drawn in ink years before anyone thought to test it. The drive back to the ranch felt longer than 20 miles that afternoon, even though the road was the same stretch of asphalt I had traveled for decades. The radio remained off, and the only sound inside the car was the low hum of the engine and the steady rhythm of my own breathing. When I turned onto the gravel path that led to the house, dust rose behind me in a soft cloud, catching the sunlight like something almost peaceful. From a distance the white fence lines looked straight and dependable, the barn roof shining faintly where it had been repaired 2 summers ago. Nothing about the land suggested betrayal. It was the people who had shifted, not the soil. I parked beside the porch and stepped out slowly, letting my hand rest on the hood for a moment as it cooled. The front door creaked the same way it always had, and the scent of lemon oil from the wooden floors greeted me as I entered. I placed my purse on the entry table and walked into the kitchen, where the clock above the stove ticked with quiet certainty. For a brief second I allowed myself to remember Daniel at 12 years old, sitting at that same table with math homework spread in front of him, frustration written across his face until William leaned over and showed him how to solve the problem step by step. That memory felt distant now, like a photograph left too long in the sun. I poured myself a glass of water and stood at the window overlooking the pasture, thinking about the months leading up to the hearing. Ashley had begun suggesting small changes last year. She offered to help organize my bills, saying it would reduce my stress. She insisted on attending meetings with the bank, explaining that modern systems could be confusing. I had watched carefully as she asked questions that sounded helpful but leaned toward control. Daniel rarely spoke during those visits. He nodded often. He trusted her confidence more than my silence. When I declined to hand over full access to the ranch accounts, their tone shifted from concern to persuasion. They spoke about efficiency, about the burden of managing livestock at my age, about how a sale could provide comfort and simplicity. They did not speak about legacy or about the mornings William and I spent walking the fence line together with coffee in our hands. The petition for guardianship did not appear out of nowhere. It was the final step in a pattern I had observed quietly. That is why I did not panic when the certified letter arrived. I had already seen the direction they were moving. That evening, after returning from the courthouse, I stepped out onto the porch as the sun dipped low over the pasture. The sky turned shades of gold and soft pink, stretching wide and uninterrupted. I could hear the distant sound of cattle shifting in the field, the familiar creak of the windmill turning slowly near the pond. I sat in the wooden rocker William built years ago and folded my hands in my lap. I did not feel anger the way I once imagined I would. I felt clarity. Daniel had mistaken patience for weakness. Ashley had mistaken politeness for surrender. They believed that because I spoke softly and kept my routine simple, I would sign away the work of a lifetime to keep the peace. They did not understand that peace built on pressure is not peace at all. As the light faded and the first evening stars appeared above the pasture, I realized something steady and unshakable. The land did not need defending with raised voices. It needed stewardship with boundaries. And boundaries, once written and signed, do not bend just because someone expected them to. The next morning the ranch woke the way it always had, with pale light slipping through the curtains and the distant sound of wind moving across open land. And I rose from bed at 6:30 without needing an alarm because routine has always been my anchor. I brewed coffee in the same percolator William insisted on keeping even after newer machines became popular, and I carried the mug to the kitchen table where his old leather binder still rested in the cabinet drawer beneath the phone. I had not opened it in months. I slid it out carefully and set it on the table, running my fingers over the worn edges before unfastening the clasp. Inside were copies of deeds, insurance policies, handwritten notes, and a yellow envelope labeled in William's neat block letters. Estate planning final review. I remembered the afternoon he finalized those documents. It had been early spring, the bluebonnets blooming along the roadside, and he returned from Mr. Benson's office with a look that was not worried, only thoughtful. He told me that protecting something you build is not about distrust. It is about foresight. At the time Daniel had just turned 40, Ashley was enthusiastic about expanding her small event planning business, and family dinners still felt relaxed. I did not question why William insisted on certain safeguards. I trusted him the way I trusted the land to hold steady after a storm. Now, sitting alone at the kitchen table, I read through the clauses again, each line calm and precise. The protective provision was not written in anger. It was written in clarity. Any beneficiary who attempted to override the grantor's authority would automatically remove themselves from inheritance consideration. The language was direct and simple, not complicated by emotion. I closed the binder gently and placed it back in the drawer, not because I feared what it contained, but because I respected it. Later that morning Daniel called. His voice sounded strained, thinner than usual. He asked if we could talk in person. I agreed and told him he could come by in the afternoon. When his truck pulled into the driveway around 3 o'clock, I was standing near the fence line watching one of the ranch hands mend a loose board. Daniel stepped out slowly, hands in his pockets, avoiding my eyes the same way he had in court. He said that the hearing had not gone as they expected. I answered that expectations often require examination. He explained that Ashley had believed transferring authority would make everything simpler, that managing the ranch would relieve me of stress. I listened without interrupting. I did not remind him that no one had asked whether I felt stressed. I did not point out that simplicity is often another word for consolidation. I only asked him whether he understood the clause that had been read aloud. He nodded once stiffly. He said their attorney had reviewed it again that morning and confirmed it was enforceable. There was a pause between us, filled with the sound of wind brushing against the pasture grass. Daniel said he had not realized challenging me would trigger such consequences. I told him that actions rarely arrive without outcomes. He looked toward the barn, toward the pond beyond it, and I could see the weight of understanding settling in. For years he had viewed the ranch as an asset, something measurable in acreage and market value. To me it was a timeline written across 40 acres. It held birthdays, graduations, arguments, reconciliations, and the quiet evenings when William and I planned the future at that same kitchen table. I did not raise my voice. I did not accuse him of betrayal. I simply stated that stewardship requires trust, and trust cannot exist where authority is taken instead of offered. When Daniel finally turned back toward his truck, his shoulders seemed heavier than when he arrived. I remained by the fence, watching until he disappeared down the gravel road, aware that what had unfolded was not a victory in the ordinary sense. It was the natural result of boundaries respected too late. The days that followed settled into a rhythm that felt almost ordinary, which surprised me more than the hearing itself. I woke before sunrise, brewed my coffee, and reviewed the ranch accounts at the kitchen table, while the horizon slowly brightened beyond the pasture. Numbers have always steadied me. They do not whisper. They do not persuade. They simply reflect what is present. I confirmed payroll for the 3 hands who worked the fencing and livestock, authorized feed deliveries, and scheduled maintenance for the tractor that had begun to rattle on colder mornings. Life did not pause because my son misjudged a legal boundary. The cattle still needed tending. The fence line still needed inspection. Responsibility has never waited for emotions to settle. On the 3rd evening after the courthouse, Daniel arrived again without calling first. His truck rolled slowly up the gravel drive, and I watched from the porch as he stepped out, shoulders squared as if preparing for a difficult conversation. This time Ashley did not come with him. He approached the steps and removed his hat before speaking, a gesture he had not used in years. He said he wanted to understand how things had gone so far. I invited him to sit, and we faced the open pasture while the sun dipped low behind the oak trees. He spoke about pressure, about the way Ashley worried that the ranch would eventually become too much for me, about the fear that unexpected illness could complicate matters. I listened carefully. Then I asked him a simple question. Had he ever asked me what I wanted? The silence that followed was longer than the question itself. He admitted that he assumed I would agree with whatever seemed practical. Practical. The word lingered between us like a misplaced tool. I explained that practicality without consent becomes control. I told him that William and I built the ranch not as a temporary asset but as a lifetime commitment. 40 acres is not a burden when you have walked every inch of it beside someone you love. Daniel stared out toward the pond, where the surface reflected streaks of orange and purple light. He said he had not meant to disrespect me. I told him intention does not erase impact. I also told him that consequences were not punishment. They were the natural result of a choice. He asked whether there was any path forward. I answered that trust must be rebuilt slowly, without expectations attached. I would continue to manage the ranch as I always had. If he wished to be involved, it would be through conversation and cooperation, not petitions and filings. He nodded, though I could see that understanding was still forming behind his eyes. Before leaving, he asked whether I regretted enforcing the clause. I considered the question carefully. Regret implies uncertainty. I felt none. I told him that boundaries are not expressions of anger. They are expressions of self-respect. When he drove away, I remained on the porch until the last of the light faded and the night insects began their steady chorus. Inside the house, I turned on the lamp in William's study and opened the window slightly to let in the cool air. The ranch remained steady, anchored by posts driven deep into the Texas soil. And I understood that what had shifted was not ownership, not acreage, not paperwork. What had shifted was the assumption that my silence meant surrender. It never had. It never would. The following week unfolded with a steadiness that almost felt deliberate, as if the ranch itself had decided to remind me what endures and what does not. I spent Monday morning riding out along the north fence line in the old pickup truck, checking posts that had loosened after a brief summer storm. The tires moved slowly over the uneven ground, and I welcomed the quiet hum of the engine beneath the wide Texas sky. Physical work has always clarified my thoughts. As I tightened a hinge and tested the weight of a gate, I considered how quickly assumptions can replace conversations. Daniel had returned twice since our last talk, each visit marked by careful words and restrained expressions, but Ashley had remained distant. Her silence did not concern me. Silence can either signal reflection or calculation, and time reveals which one it is. On Wednesday afternoon I received a letter from their attorney, formally acknowledging the forfeiture and confirming that the trust provisions would remain in effect. The language was polite, almost apologetic, as if legal vocabulary could soften the outcome. I placed the letter in William's binder without comment. Documents do not require emotional responses. They require organization. Later that evening Daniel arrived again, this time with a different tone. He asked whether he could walk the property with me. We moved slowly along the gravel path toward the pond, the sun lowering behind the trees and casting long shadows across the pasture. He pointed toward the western acreage and mentioned that developers had once offered nearly $300,000 for that section alone. I nodded. I remembered the offer clearly. William and I had declined without hesitation. Some values cannot be measured in market proposals. Daniel asked if I had ever been tempted to accept. I told him temptation depends on what you believe you lack. We never believed we lacked anything essential. He grew quiet at that, studying the water's surface as wind rippled across it. After a while he admitted that he and Ashley had calculated potential profits more than once. They believed expansion or sale would secure their future. I stopped walking and faced him. I told him security built on someone else's displacement is fragile by nature. He lowered his gaze. and I could see that the realization was beginning to settle deeper than before. I explained that the forfeiture clause did not exist to exclude him. It existed to protect stewardship from force. Had he approached me with partnership instead of paperwork, the conversation would have unfolded differently. He asked if that possibility still existed. I answered that partnership requires humility first. The ranch was never a prize to be claimed. It was a responsibility to be earned. We stood there for several minutes without speaking, listening to the wind move through the tall grass. The land did not react to our tension. It remained steady, patient, unmoved by ambition. As we walked back toward the house, I sensed that Daniel's posture had shifted, not in defeat but in understanding. The path forward would not be immediate or easy. Trust does not regenerate overnight like grass after rain. It grows slowly, through consistent actions and honest dialogue. When he left that evening, he thanked me quietly, not for the land but for the conversation. I watched his truck disappear down the road, then turned back toward the house where William's lamp still glowed in the study window. The ranch was unchanged in acreage and ownership, yet something subtle had begun to recalibrate. Not the legal documents, not the fences, the expectations. By the end of that month the ranch felt quieter in a different way, not heavy with tension but aware, as if every fence post and oak tree had witnessed the shift and was waiting to see what would follow. I continued my routines without alteration. I reviewed invoices at the kitchen table, scheduled hay deliveries, and met with the agricultural extension officer about soil maintenance for the south field. 40 acres require attention, not drama. One afternoon Daniel called and asked whether Ashley could come by to talk. His voice carried a caution I had not heard before. I agreed and suggested Sunday after church, the same time we once reserved for family lunches. When they arrived, Ashley stepped out of the truck more slowly than usual, her posture controlled, her expression carefully composed. We sat at the long wooden table in the dining room where William and I had hosted countless holiday meals. Sunlight filtered through the curtains and fell across the polished surface, highlighting every grain in the wood. Ashley began by acknowledging that the petition had been a mistake. She spoke about fear of uncertainty, about wanting stability for their future children, about misunderstanding the strength of the trust. I listened with steady attention. I did not interrupt. When she finished, I asked whether stability built on removing someone else's authority ever truly lasts. She did not answer immediately. Daniel reached for her hand, and for a moment the room felt suspended between pride and humility. Explained that the forfeiture clause was not revenge. It was structure. It existed because William believed stewardship should not be seized. Ashley's eyes shifted toward the window, toward the pasture stretching beyond the glass. She said she had seen the ranch only as land value and potential equity. I told her that perspective shapes behavior. When you see something only as profit, you treat it like a transaction. When you see it as legacy, you treat it like responsibility. The difference is not subtle. The difference is everything. Ashley nodded slowly, and for the first time since this began, her confidence seemed replaced by reflection rather than calculation. She asked whether there was any way to contribute without control. That question carried more sincerity than the earlier legal arguments ever had. I answered that involvement begins with learning, not ownership. If she wished to understand the ranch, she could join me during inventory reviews, accompany me to meetings with suppliers, or walk the fence line with Daniel to see what maintenance actually requires. Authority is earned through presence, not demanded through paperwork. The conversation lasted nearly 2 hours, unfolding without raised voices or accusations. When they stood to leave, Ashley paused near the doorway and said she had underestimated me. I told her that age does not diminish clarity. It refines it. After they drove away, I remained at the table for several minutes, absorbing the quiet. The ranch outside the window appeared unchanged, yet the air felt lighter, as if expectation had been replaced with understanding. I knew trust would not be restored in a single afternoon. It would require time measured in seasons, not days. But something essential had shifted. The conversation had moved from entitlement to participation. And that, more than any clause written in ink, was the beginning of something steadier. Autumn arrived quietly over the ranch, the way most meaningful changes do, without announcement or spectacle. The grass along the pasture shifted from deep green to a softer shade of gold, and the mornings carried a cooler edge that lingered against my skin when I stepped outside with my coffee. Daniel began coming by twice a week, not to negotiate or persuade, but to observe and assist. He rode with me along the fence lines, asked questions about feed ratios and seasonal rotation, and listened more than he spoke. Ashley joined us occasionally, her boots still too clean for ranch work but her attention steady. She took notes during meetings with suppliers and asked thoughtful questions about water usage and conservation practices. I did not mistake these gestures for transformation. I saw them as effort. Effort, unlike entitlement, has weight. One afternoon as we reviewed inventory in the barn, Daniel paused beside the old tractor and ran his hand along its worn red paint. He said he had forgotten how much maintenance the land required. I told him that ownership is less about title and more about responsibility. The words were not meant as correction. They were acknowledgement. Later that week we met with Mr. Benson to clarify how the charitable foundation would continue receiving its allocation under the trust. Daniel listened carefully as the attorney explained the structure William had designed. When the meeting ended, Daniel thanked him without tension in his voice. It was the first time I had seen him accept the framework without trying to adjust it. On a clear Saturday morning we walked the western acreage together. The section developers once pursued with generous offers. The wind moved gently across the open field, carrying the faint scent of hay and distant cedar. Ashley stood beside Daniel and said she could understand now why William refused to sell. The land did not feel like unused space. Felt like continuity. I watched her expression as she took in the horizon, and I sensed that something fundamental had shifted. Not in the documents. In perspective. That evening I sat alone on the porch as the sky turned a muted shade of amber. I reflected on how quickly assumptions can fracture families, and how slowly understanding repairs them. I had not enforced the clause to isolate my son. I enforced it to protect the foundation William and I built with intention. Protection does not require anger. It requires clarity. In the weeks that followed, Daniel continued showing up without expectation attached. Ashley asked to help organize historical records from the early years of the ranch, treating them as archives rather than assets. Their approach carried humility I had not seen before. Trust was not fully restored, but it was being rebuilt in quiet increments. As the first leaves drifted across the yard and settled near the porch steps, I realized that what began in a courtroom had ended in something steadier. The ranch remained mine to steward for the rest of my life, just as William intended. The forfeiture clause still stood, unchanged and unchallenged. Yet the most important shift was not written in ink. It was written in behavior. Boundaries had been tested, upheld, and finally understood. And under the wide Texas sky, with 40 acres stretching steady and unclaimed by haste, I felt something rare and simple. Not victory. Not triumph. Just balance.